Welcome to Health Law Talk, presented by Shahardy Sherman Williams. Health law broken down through expert discussion, real client issues, and real-life experiences. Breaking barriers to understanding complex healthcare issues is our job.
And good morning, everyone, or good afternoon, whenever you're listening. Welcome to another edition of Health Law Talk. We are very excited to have you here listening to this podcast. In the studio today, Conrad, Meyer, and Rory, Bellina, two very accomplished healthcare lawyers who are going to help you navigate some of the wonderful healthcare policy and healthcare regulation that's going on currently in today's world. And today, Rory, very interesting, reproductive rights post-Dobbs, right?
Yeah. Today's going to be a really good topic. I think it's very timely to do, and we've got a lot of insight into this.
Yes, aside from the ruling itself, we're looking at this from a total healthcare perspective. So, what is the sequela in terms of post-Dobbs with the trigger laws in some states, and what are some of the issues that could pop up that people, really providers, might not be aware of, and people who are going through the reproductive issues, whether it's an unwanted pregnancy, IVF, maybe a failure to thrive on a fetus. What are their options now relative to post-Dobbs?
Sure, and I think we could start with, I know we were talking about this beforehand, is what was the landscape pre-Dobbs and then post-Dobbs?
Yeah, so pre-Dobbs, there was the national. You had Roe v. Wade had basically a national right to an abortion, and I know that various states had challenged that, and there was a lot of different exceptions to that with respect to rape, incest, even failure to thrive on fetuses and embryos. With IVF, you had something called selective reduction, where if you had implanted more than one embryo into a woman for the purposes of giving birth, and one of those embryos or both of them took, but then one, they both grew, and you had twins or even had triplets that could threaten the life of the mother, you could do what's called selective reduction, and that was still okay in some states. So, a lot of things changed post-Dobbs because of the trigger laws, and you know what I'm talking about.
Sure. And Dobbs, I think, just for everyone listening, was kind of the case per se that I guess you could say overturned everything. And so,
well, it didn't overturn everything; it just punted it back to the states.
Correct. I think that you hear, or at least I heard in the media, that this case overturned it. You're right. It wasn't an overturn. It was we're returning this to the states' rights. And a lot of states, Louisiana included, had these trigger laws per se that were going to go into effect immediately, kind of in anticipation that this was going to happen.
And there was 13 states, just to be clear. So there were 13 states that had trigger laws that were ready to go into effect the moment that Dobbs, or the moment that the Supreme Court had overturned Roe. And so now, there's been an extensive analysis of these 13 states and their trigger laws. One goes back to 1931. So, we're not going to go into each of those states, sure, not for this episode, but it does change the landscape for reproductive rights with respect to individuals who are going through these various issues that we thought we would broadly discuss. And I guess one of the first things, really issues that kind of like you don't think about, right? So, for example, contraception. The Plan B pill. Is that considered an abortion? Is that now, because of a trigger law, going to be banned, where someone might have to go across the state line to another state that doesn't have this to be able to get a Plan B pill, right?
Right. And like you mentioned, it's not very clear what is considered terminating a pregnancy or terminating a life. Every state kind of has a different definition or explanation of what is considered conception, what is considered life, what is considered a viable fetus. So it becomes very complicated not only for the providers, for the physicians that are dealing with these questions, but just for the general public where they don't know. And I mean, we've seen in the news recently, I believe there was someone in Louisiana who had to travel to New York for this, is, you know, if you're in the situation where you find out that you're pregnant, or if you decide that you have an incident and you want to take the Plan B pill, what do? It's almost like you have to, you talk to your doctor, but your doctor's going to want to talk to their lawyer. Mm-hmm. It becomes a whole process. And we hear about this, the big headline stories of, doctors are not performing abortions because even if the mother's life is at risk, because they're concerned that it doesn't meet the criteria. So there's a lot of moving parts, and it's evolving. And I think that providers and patients especially are having to figure this out on the fly.
Well, here's another thing. Let me confuse you, or really the provider, even further. Cross-border battles. So, in other words, let's just say, for example, Texas, which has a ban. Okay, now that Dobbs went in effect, they have a ban, but somebody wants to travel across a state line to another state for an abortion that doesn't have a ban. And now Texas is saying that, well, if you go to another state for the purposes of an abortion, we're going to come after you. But there's nothing in the trigger law that says that they can do that. So can Texas or any other state, I'm just not picking on Texas,
sure,
right? Any other state that has a trigger law that's now in effect that bans abortions, and that person crosses a state line into another state that doesn't have a ban, can that home state then take action, legal action, against the provider and the patient?
Yeah, and when I saw that, that was really interesting to me, because most of the rules, across the states, specifically in Louisiana, for telemedicine, for example, it's all about where the patient is located.
Right.
That is, so if you've got a patient that's located in Louisiana, and if the telemedicine visit and the doctor's out of state, it's considered a visit in Louisiana. So when I saw that, a patient traveling out of state to Illinois to have an abortion performed,
right?
Does Texas have any action over a Texas resident who has a legal medical procedure in Illinois?
I don't think so.
I don't know.
My gut tells me, from a jurisdictional perspective, there's no personal jurisdiction. If it's not written in the statute, I don't know how Texas can enforce a Texas law, right, on an individual in another state that does an action in another state. You
correct.
follow me?
A legal action. Correct.
So think of the sequela from that. I mean, think about that. If you go, say you go to another state, not for an abortion, but for something else.
Sure.
Right. So does that mean that if Texas has a death penalty, if they're a death penalty state, but then the individual goes to, I don't know, a non-death penalty state and kills someone, does that mean that Texas can bring a death penalty criminal action against the individual for killing someone out of state?
Again, I don't see how they could do that, because there was no action in the state. So, but it's really interesting that Texas has taken that position, and I presume it's more for political reasons than anything.
It's not just Texas, though. Let me just say that. It's not just Texas. They have other cross-border battle states that are doing the same thing, that are looking at legal action against people and providers. So, I mean, imagine a doctor, like you just said, in Illinois, who does the procedure.
In Illinois.
Right, who's licensed by the Illinois board, not Texas.
Right. How
in the world could Texas have jurisdiction over that provider?
I don't see it.
I don't see it. Sorry. You can posture on the podium in front of a TV all day long, but that would open. Do you know the can of worms that would open up? I mean, just think about it legally. If you did that, or somehow if that was magically allowed, like you could wave a magic wand and say, "I'm going to get you if you go to another state." That's crazy.
Absolutely, yeah. I just
sorry.
I don't see the relation, but
it's there. I mean, they're talking about it. I mean, so cross-border battle. So you're gonna have to look at whatever state you're in. I mean, I'm going back to our purpose, right?
Sure.
The providers. Look at what your state law or your state is saying, especially from your medical board. I mean, your local medical board should be pushing out, at least guidance for you on this, because if they're not, I mean, I think especially if you're a physician who practices this in this area, you're going to be in trouble. You won't know what to do.
You need some guidance. Absolutely.
Yes. So interestingly, I saw this reference the other day to EMTALA. Okay, so and what happens now if you go and you present to the emergency room, and we all know what EMTALA is, okay? But for our listeners, do you want to give a quick? I mean,
sure,
some EMTALA so they understand what that is.
Yeah, so EMTALA was put into place, and the full acronym is Emergency Treatment. Emergency. I honestly I don't remember.
Emergency Medical Treatment Access Labor Act,
something.
That.
Yeah,
we just call them EMTALA.
EMTALA. Yeah, it's this long acronym, but basically it was kind of an anti-patient dumping regulation that was put into place because you saw a lot of, and also required that if you were to show up to an emergency room hospital,
right,
that you had to be stabilized and or treated and or transferred out. And there's different criteria and steps to that, but it was kind of dubbed the Anti-Patient Dumping Act.
Right.
And so that's the general premise is that if you are, let's say your arm was cut off or something like that, and you go into an emergency room and it's a hospital that has a valid emergency room and they take emergency patients, they can't deny you services based on your ability to pay or inability to pay.
Right.
And they have to stabilize, treat, and or transfer you out. They can't just dump you somewhere else because they know that you're not going to be able to pay for it.
Well, they have to screen you. They
Correct.
have to do a screening. They're required to do a screening and determine whether or not you're in an emergency medical condition.
Correct.
So if you're in an emergency medical condition, again, same thing, render treatment regardless of the ability to pay to stabilize you and transfer you to a higher level of care, right?
Correct.
Here's the issue with EMTALA. So think about this, because remember, it also involves pregnancy. If you're in active labor, okay, and you present to the emergency room. Now, remember, the emergency room is any hospital that's literally advertising the emergency. They have the emergency sign out.
Correct.
They've got that. So John Doe, Jane Doe looks at it and say, hey, that's an emergency room. Then you're bound by EMTALA, right?
Correct.
So they present in active labor under EMTALA. Then only during the screening they have to determine labor, right, and determine if that's an emergency medical condition or not. So what if, and here's the EMTALA thing, going back to reproductive rights,
right,
or the whole purpose of this. What happens if you're in a state that has an abortion ban, but you present to with no exception, like no life of mother, no life of child, no anything exception, a strict ban, okay? But you present to the ER and you're screened and you're pregnant and you're in an emergency medical situation and the doctor determines that requires an abortion. What happens next? What preempts?
Yeah, I mean, it again, this goes back to the state question, and I'm just familiar with Louisiana because that's where we're here, is that by statute there's certain criteria that physicians are allowed to provide abortions under, and it's different medical justifications and medical reasons. So I think that is what is going to come into play and kind of govern the decision. The physician is going to have to know, almost have kind of a cheat sheet in his or her pocket saying, okay, here's what's going on. Is this covered under the statute for me to be able to perform this abortion or not?
Well, the question is, really, does EMTALA preempt state law, or does the state trigger law apply? You follow me? In other words, what law trumps what? Does the EMTALA law requiring emergency action to stabilize the patient? So if the physician determines that the patient's in an emergency medical condition and is pregnant, and in order to save the life of the patient, that they must abort the baby, but they're in a trigger ban state, so the state law prevents that. So what law would trump? The federal EMTALA law to save the patient?
To stabilize.
Correct. Or the state law, trigger ban. I mean, do you see
yeah?
And as a provider, you would have no. I mean, do you think you're?
Well, you don't have the time to figure this out, or to call in-house counsel, or you don't have the time to figure that out when you've got a mother who's potentially bleeding out in your ER.
Right. So do you see the conundrum? So that's an EMTALA conundrum.
Sure.
And so that's why I think
in Louisiana statute, I don't believe it has it's got some emergency criteria in it.
It does. It's life of mother, life of child.
Yeah,
I believe
it's got those, but it's still not as clear as it could be, or really should be.
I think some of the states, some of the 13 states that have that trigger ban, from post-Dobbs, like are even more strict, an absolute ban.
Right.
So when you have the absolute ban, if you're the provider, I think they would just go ahead and do the abortion for the life of the mother, right? I would think that's what they would do under EMTALA, and then wait to see what the court does. See if the court actually, does the what you call it?
Wait and find out if there's any action by you from the medical board,
or someone sues you, right? Because you did the abortion.
Yeah. That those are all possibilities.
So interestingly, one of the things that I found out, and that was interesting to me on reproductive rights, because it's not just about abortion too, IVF. So in vitro fertilization, which is very interesting, states have different laws regarding that. They're very, friendly IVF states. They're very unfriendly IVF states. For example, Louisiana does not, I find, is a very unfriendly IVF state, meaning, in other words, it only helps the couple. So if you're a couple that is unable to generate eggs, or oocytes for your own children, or if you have a medical condition when your sperm isn't you're unable to generate sperm adequately enough to fertilize and have your own children. If you wanted to get an egg donor or a sperm donor in Louisiana, they don't allow that.
Really?
Nope, they don't allow that. You can't do it. You would. It's a prohibition. And interestingly enough, if you did secure a surrogate to carry a child in Louisiana, you would have to go through the adoption process in order to have your own baby. So, which is very interesting because, for example, Mississippi and Texas don't have that problem. Texas is very IVF friendly, very surrogate friendly. Mississippi seems to be the same way, but we don't have that. And so, from a reproductive rights standpoint, kind of pivoting here for a second, it's really interesting. And why I lump this in on the abortion side is because a lot of times families who, or parents or couples who want to have children sometimes implant more than one embryo. So, for example, they want the greatest success or the greatest chance of success to have a child. Okay. And so in order to achieve that success, they will say, okay, instead of just planting one embryo, I'm going to have a greater chance of success if I plant two.
Okay.
Sometimes even three. Now, IVF doctors now have seemed to kind of sway away from that. They don't want to do that.
Sure.
But the reason is because of the problem I'm about to bring up. And the problem is that there is a chance, if you implant one, right, which would be okay, everybody wants that one embryo could divide and create two. So you could have actually two babies, two kids, have twins. If you implant two, there is a chance that it could multiply into three or even four.
Sure.
And at that point, when you have triplets or quadruplets,
right,
it really, really comes into play that the health of the mother is in real, could be in jeopardy, because the likelihood of triplets and quadruplets reaching a term birth it decreases because there's just not enough room. So they have to do, there's an issue there.
That's what I want to ask you. I want to go back to something you said earlier in this. So Louisiana, with either sperm donation or egg donation, what's the status on that?
That you cannot actively go out and seek a donor in Louisiana for gametes. In other words, I can't, if I am unable to generate sperm, or my wife is unable to generate eggs because of whatever medical reason or age, we cannot go out and secure a donor as of now in Louisiana to be able to donate their gametes to help us have children.
So what do these clinics do that are here? Like
they refer you out of state.
So all the fertility clinics in Louisiana essentially refer you out of state? If
you want to go that route, yes.
Interesting. Okay.
Now, what is allowed, in other words, if I gave and donated my sperm, or your partner donates her own egg, you can do IVF that way, okay? But I can't go out to Tulane or Loyola, right, or some university like LSU, any place, and advertise, hey, if they're healthy females who want to donate their eggs, I can pay X amount of money. That's not going to happen.
Okay. And so all the fertility clinics, even in Louisiana, if you were to go to a fertility clinic and say, I want to have a child, I would like to procure sperm donation. I'm a female. I make my own eggs. I want the sperm donation. That's not, you're sent out of state for that?
Yes.
Okay.
Yes, because because Louisiana has a prohibition on that.
So you go out of state to have the
donation
or the implantation made, and then you come back here for your treatment?
Yes. So in other words, let's say for example, you wanted to get a sperm donor because you're a single mom and you don't have a couple.
Single
person, right? Or you're a male. You're a male and you want to have a child. You don't have a significant other, or you're a couple and you're unable to have children for whatever medical reason.
Okay.
All
right, I'm following.
You can't. You would have to go to we went to like Texas, right?
Texas or
Mississippi, right?
Okay.
And then there are clinics there that would allow sperm donors and egg donors, and they have whole programs. I mean, you're talking about people who vet people through various medical and social to determine if there would be a qualified sperm donor or a qualified egg donor. They have companies that do this.
Okay.
And then you would work through your fertility clinic and a donor company to secure what you need.
Okay.
So
and you have to physically travel out of state for the implantation to happen.
Correct. And for the birth. I mean, the implantation, yes, because it's prohibited here in Louisiana, right?
All right.
But and for the birth, remember now, because if you let's just say Jane Doe, say you're a man, a couple, or a woman, who couldn't carry a child for whatever reason, right?
All right.
Men, obvious. Couples for their age or whatever medical reason, or a woman who might, for the age or other medical reason, cannot carry a gestational child to, gestational carrier to birth. So you'd have to hire a surrogate.
Okay.
And say you did that. If you did that in Louisiana, okay, and you went and you did your IVF, donor in Texas or whatever, and they did what's called a frozen embryo transfer or a live transfer, meaning, in other words, once they get the gametes from the donors or the couple or whoever,
right, and
they fertilize them in the petri dish, right, and they form embryos, they grow them out for so many days,
okay,
then that surrogate that you have located, usually have companies that do this, but would go to Texas or whatever, and they would get implanted with the embryo.
All right, I'm following.
Okay, so then that person, say that person's not from Texas, say that person lives in Louisiana.
In Louisiana, yeah, I like that example.
Okay, it's right across the border. So the problem is if that individual give birth in Louisiana, there is nothing in Louisiana law that would allow the intended parents,
the parents who the husband or whoever it may be, that
husband,
essentially
wife, or couple
that essentially paid for all this,
right?
Okay.
There's nothing in Louisiana law, and there's a prohibition in Louisiana that they cannot. Those parents or those individuals will not be on the birth certificate if that woman gave birth to the child in Louisiana.
Okay, so they're not on the birth certificate. What if they're? I assume there's contracts involved in this, right?
Numerous.
Tons of legal contracts.
Absolutely.
Is that I want to go back to the example of the surrogate giving birth in Louisiana, and you have a contract for this with the couple who's essentially paying for all this.
Yes.
When that mother when the surrogate, I want to make sure I use the right terms. When the surrogate gives birth in Louisiana, is the surrogate contractually obligated to, what's the word? Give up for adoption the baby?
Yes.
So the contract is valid and binding in Louisiana.
That's remained to be seen.
Okay.
Because I don't think it's ever been challenged.
Okay.
But I know that there's no hospital in Louisiana that would ever put the original intended parents' names on the birth certificate.
So their names aren't on the birth certificate.
So you have to go through adoption.
So you would have to go through the
surrogate.
And my concern would be that
your name's not on the birth certificate.
If you walk through this whole process, you're the couple who can't carry. You go through one of these companies, you hire a surrogate. I know this is very expensive. You pay for the implantation in Mississippi or Texas. And then the surrogate comes back here, gives birth.
Yep.
in Louisiana
And decides not to want to get the baby up.
Yeah, what happens there? And then she says, "I'm not putting up this baby that you essentially paid for adoption." What happens there?
That's the problem, and that's a risk, I would think.
So what's the alternative? You give birth in Mississippi, and what happens there?
You find a surrogate in a surrogate friendly state. So, for example, Mississippi is a surrogate friendly state. So, if you execute a contract in Mississippi, because Mississippi does allow this, amazingly, Mississippi, right? You would think Mississippi, really?
Yeah, they're almost more conservative than Louisiana.
Unbelievably so. The state of Mississippi allows this to happen.
So upon birth in Mississippi, same example. By the surrogate, what happens?
We've got to walk back a little bit because Mississippi has a couple of other steps.
Okay.
So in other words, you sign the contract with the surrogate.
Okay.
Whether it's a couple or a single parent, right? You must get a Mississippi judge to issue an order blessing that contract. Sorry, the contract.
Oh, wow. Okay.
So once the Mississippi judge issues the order that it's a valid contract.
Okay.
That order, along with the contract, is given to the hospital where the birth will take place.
Okay.
That order instructs the hospital to put the intended parents on the birth certificate for vital records. So then you walk. If you're the intended parent or parents,
right,
you walk out the hospital with your child with the birth certificate that's going to be in your name.
So you're essentially, the judge is ordering the hospital to essentially skip the process of adoption. That's cut out. There's no adoptive process.
Right.
It's your child.
Because the court has blessed this, yes.
Interesting.
Isn't that interesting? And it doesn't happen in Louisiana.
That's really interesting.
So I know we kind of taking a pivot on this.
No, this is
from reproductive rights.
It's interesting. So what is, in your experience on this is very new to me, what is it strictly religious or political in nature, why Louisiana is a little bit more conservative?
I think it's both. I mean, I think our brothers and sisters right up in the North Louisiana are very religious, and I'm not. I mean, of course, I'm very religious. I'm very Catholic, so I understand. Yep. So, I think it's a lot to do with that, and also I don't know if any of our representatives have really delved into this area of the law. So I don't know if they're really cognizant of in other words, of the technology of how things have advanced.
Sure.
So I could see some ignorance or just lack of understanding or lack of awareness.
Yeah, and if a constituent's not bringing this up to you, if it's not an issue, then why are you going to write a bill to change this, to get slaughtered in the House or the Senate from the, like you said, the more conservative parishes?
Isn't that interesting? So
that's really interesting, and I was really unaware of the relationship between fertility clinics having to refer out to.
So if you're a fertility clinic here
in Louisiana, a female walks in and says, "I want a sperm donor. I don't want to get, for whatever reason, I want to have a child on my own."
Yeah, you're gonna have to go out of state.
They're gonna set you up as a client and everything.
Yeah, they're gonna run tests on you to make sure that you are capable. Like, in other words, you are what you say, and you want to have a child, and maybe check your oocytes to make sure that you can produce an oocyte for fertilization, and then refer you out to a state, probably Texas, because it's right next door.
Right,
it's very, very friendly
for the implant.
For the donor
to receive for the donation
and subsequent implant in Texas.
Okay.
Because remember now, let's just say if it's the individual, say that person can gestationally carry.
That's my example, yes.
So in other words, based on your example, that person would go to Texas, get the donor sperm, have the IVF done in Texas, do the implantation in Texas, but then come back to hit her house and carry the baby to term, and when she bears the baby, it'll have her name on it.
So everything else after the implantation
would be fine.
Can occur in Louisiana.
It's when you have a surrogate that's
surrogate is different.
It's different.
Interesting. And it's all about, for surrogacy, where the birth takes place. It's not where they carried the child. I mean, it's all about physically. They have to, even if your surrogate's living in Louisiana, when she becomes due, she needs to go across the border.
Yeah. I mean, I've never challenged that. I've never tested that.
Sure.
But I know I know that the Mississippi court order, for example, in that Mississippi example, that is directing the hospital to follow the gestational carrier contract.
Got it.
And you got multiple in terms of reproductive issues, and now we're focusing on IVF. You've got the fertility clinics. You've got who a lot of times also run a separate side hustle, not a hustle, but a side business of donors.
Sure.
So the fertility clinics in a very IVF friendly state are going to be doing donor programs. So they're going to be out like screening donors, both sperm and egg, and incorporating that. This is a huge business.
I'm sure.
It is a massive business.
Is any of this?
You're talking tens and thousands of dollars of money.
I was going to say that's what my next question was. Is any of this covered by insurance?
I mean, there are very, very, very few policies that would ever cover IVF.
Okay.
And there's been ways to attack it. I mean, there's been ways. I mean, because they do say that infertility can be considered a diagnosis, right?
Right.
So I know there's been challenges to it. I know there's been discussions about it. But I mean, I don't know of many, if any, sures that would ever carry, just because of the sheer cost.
Now, let's say you're implanted. I assume your insurance covers your labor and delivery and maternity, right?
That's different. So, in other words, I mean, I think even a surrogate, you would have insurance cover. I've seen some insurance companies, they won't cover the IVF,
right?
But they will cover the surrogate delivery cost.
Okay, and whose policy? The actual surrogate?
No. Well, that's a good question.
Meaning, here's my thought: if you've got a surrogate who makes their job out of this per se, let's say, because I know a lot of surrogates do this more than once, right?
Yes.
So let's say that this person, this is not a good expression, but like this is their job. They're a surrogate, and they just,
I wouldn't call it a job. I would call it a calling.
A calling. Okay. The surrogate has this calling to continue to carry children for couples.
Yes.
Is that surrogate's Blue Cross policy going to cover all these, weekly, monthly visits to labor? Because I feel like it's not overused, but I mean,
their policy would cover that. You, as the intended parent under the gestational carrier agreement, would cover the deductibles of whatever policy that person had.
Okay.
And I think there is a.
I'm just surprised the insurance companies are willing to do that, because most people have 2 to 3 kids on average.
Well, they can't stop it. I mean, in other words, if you're under the policy and you're a covered individual or covered beneficiary,
right,
and you're pregnant, regardless of whose child it is.
That's true. I could see the insurance company saying, "Wait a second, like you're having too many kids. You're making money on this now. Like
How would that look?
Right. You're right. And insurance companies aren't hurting, so
yeah,
that's fair. I just didn't know what. I didn't know if that was an exclusion or something. No.
I mean, I think you have you got to cover the deductible, right?
Right.
Right. But I still think that it would be covered under the policy. It would be covered as a covered expense.
Sure.
They can't. I don't think they can't stop that. So
interesting.
I mean, I got to tell you, it's not only interesting. It's one area of the law that literally has numerous legal issues and ramifications that most people aren't even aware.
And I think that this area, the whole reproductive rights, if you look at any area of medicine, I'd venture to say that the whole reproductive field is probably the biggest medical area that is influenced by religion and politics over anything else.
I mean, you have the religious right that would say that, the Vatican is against IVF.
Correct.
You would have some Catholics that would say, and maybe not some, but a lot of Catholics would say, well, divine intervention. If the Lord gave someone the ability to build and create this, then it's divine intervention, and therefore it would be acceptable.
And it's not just. I don't think it's just Catholics. I think it's you've got religions all across the state, wherever you may be, that believe that none of this should happen, so they're not going to write a bill, they're not going to sponsor a bill, and they're going to kill any bill that comes across. So the law is never going to catch up with it, as opposed to other states that are more progressive, where they see the medical need for this, how people are progressing, and why they really do need it.
Well, really, I think one of the issues that has not been addressed yet, and I'll be candid with you, I don't know how often it happens, but it's still an issue, and it's the selective reduction.
And you can explain that.
So if you get a situation where you've got more than one embryo implanted and both are growing, or one has divided into two, or if you put two is divided into three, or whatever.
Okay.
And as the babies continue to develop, what happens in a couple situations? What happens if one of those fetuses now, as it grows, fails to thrive, and you have a situation where the fetus is causing harm to the other fetuses, and you have to selectively reduce? Or the fetuses are getting so big that there's no choice. You have no choice but for the safety and health of the mother, and you have to pick one. You know, I mean,
that's technically an abortion, right?
That's correct. So what do you do?
And here's this is you don't have to answer this because I don't think there is an answer to this. If you're in, like you said, Mississippi, you've got this contract,
right?
And the embryos split, and now you've got more than one, and it could potentially harm. I assume these contracts probably contemplate for this, but
they do.
If the mother or the surrogate is at risk, you know, or let's say the parents want they want the triplets, but the surrogate doesn't want to carry the triplets. I mean, what happens there? Is that in the contract?
It is, and it's amazingly, it's contemplated in these agreements, in these gestational agreements, where the surrogate makes the call. The surrogate makes the call along with her husband, or if she's not married, the surrogate herself is the sole person that can make that call, with advice or input from the intended parents. But ultimately, it lies with the surrogate.
Correct. And then again, if it's too many, and the surrogate in Mississippi is traveling to Illinois for an abortion. It's just.
Do you see the conundrum now? So if the state law, in effect, it does not allow an exception for life of mother, right?
Right.
Or if there's a failure to thrive, or there's an issue in terms of a disability or whatever with the fetus in utero.
Sure.
If the state law doesn't have an exception for that, well, then what do you do?
Sure. Or what if it's really not life of mother? What if the surrogate just doesn't want to carry three? But I mean, the issues are endless, because you've got possibly a Louisiana couple with a Mississippi surrogate who's having to travel to Illinois for an abortion. It's just, it's crazy. 3 states, 3 different sets of laws. It's a lot.
And how can you? And just think about the couple, right? Who has probably spent, close to 6 figures to have this child that medically they're not able to have.
Sure.
And a surrogate who wants to help.
Sure.
Is now faced with a terrible decision to make. And then they're in a state that doesn't even allow that type of, that bans that sort of scenario from ever occurring. Right. So, anyway, look.
And they've got that Mississippi contract that was just blessed by a judge, but in Illinois, it's not going to be valid. I mean,
no. So the whole purpose of the show today was to talk about the issues.
Sure.
And these are good issue spots. Now, we've sort of pivoted to IVF at the end.
No, but I mean, it's all under reproductive rights.
It's all under reproductive rights. So when you look at the post-Dobbs, when you're looking at IVF, when you're looking at EMTALA, when you're looking at border battles, when you're looking at, we are in for a legal conundrum on all of the issues that are going to have to be, I think they're going to have to be either worked out in the courts.
Sure.
Or the individual state legislature is going to have to do something to address all of these issues.
And I think that, like I mentioned earlier, this is a very political, and out of any field of medicine, how we said this is a very political and religious. I think that in the practice of medicine, most physicians or the kind of the rules and regulations are similar. The various boards of medical licensure, or board of medical examiners, whatever the state calls it, they pretty much follow the same set of rules. But this is that one field of medicine where every state is different, and I think that that's really important, difficult for the providers, difficult for the patients, because most states follow kind of the same rules on telemedicine. They follow the same rules on elective procedures. This is state by state, and it's really, really interesting.
And the sad thing is that when you look at the scenarios, just the brief ones that we talked about today, most people really don't understand. And even providers providers who are in the trenches, most of your OBGYNs, who are doing this, fertility physicians, maternal fetal, specialists who are involved with this type of work, are going to be confused. They're not going to know. All they want to do is practice medicine.
Right.
You know that.
Right.
So, and then you got people who ultimately are also confused, because I could tell you this: it's a very stressful, emotional, especially on the IVF side, journey.
Sure.
And I'm sure it is for the, I'm sure it's extremely stressful for patients on post-ops on the abortion issue.
Sure.
So anyway, it's definitely.
Yeah, I mean, these fertility clinics must have to give you some sort of. Do they refer people out for legal advice? Because
they do. I mean, I know they do. I mean, I've talked to a couple of fertility lawyers in Texas and even in Mississippi, who they don't really go as fertility lawyers. They call themselves they're just really family lawyers, but they know about the fertility issues. So, who have helped formulate these contracts.
Sure.
So I think. It's another step in the process of how to navigate some of these very complex legal issues that a lot of times I think the news media or others just either don't cover or legislators just simply fail to address because they just don't understand the complexities of how the ripple effect, right, of what happens when you're dealing with some of these issues.
Yeah. Man, very interesting topic today.
Well, great. Well, look, thank you very much. Any final thoughts, Rory, before we close out?
No. I think this was a really good topic, and like I said, it's the one field of medicine that I feel is different state by state. It's got so many religious and political factors in it that really kind of overlay on the actual medical aspect of it. It's evolving, especially post-ops.
Well, look, what I want to just say this, and I know we've talked about this before we close out. Listeners, if you have any comments, requests, anything like that, please send us an email directly. We don't have that bulletin board or a blog that you can just sort of post comments on. So the only way we get feedback and the only way we get comments is if you send us an email. So, Rory, can you tell the listeners what the email is? I don't know if I forgot the email.
Yeah,
What's
it's podcast with a plural, podcast with a S. at shahardi.com, and it's also going to be listed in the description for the podcast show as well. Fantastic. So everyone, please, we really appreciate your thumbs up, that 5-star rating, and we really appreciate you sending us your comments and requests. This is another episode of Health Law Talk. Rory, Bellina, Conrad, Meyer signing off. Until the next one. Enjoy. Thank you.
Thanks for listening to this episode of Health Law Talk, presented by Shahardi Sherman Williams. Please be sure to subscribe to our channel, make sure to give us that 5-star rating, and share with your friends. Shahardi Sherman Williams is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does this podcast establish an attorney-client relationship. Reference to any specific product or entity does not count as an endorsement or recommendation by Shahardi Sherman Williams. The views expressed by guests on the show are their own, and their appearance does not imply an endorsement of them or their entity that they represent. Remember, please consult an attorney for your specific legal issues.